And this is where we start. Public Protector Busisiswe Mkhwebane's fitness to hold office case resumes. So tomorrow the Constitutional Court will hear whether the appointment of a judge to the panel is compliant with the separation of powers doctrine. In July, the Western Cape Division of the High Court dismissed Mkhwebane's bid to have the rules for removing the Public Protector declared unconstitutional. Advocate Modidima Mannya joins me now live. Advocate Mannya, thanks indeed for joining us this evening. We appreciate your time. So the real issue here, I guess, is that the Public Protector says that the appointment of a judge on the panel is against the separation of powers. What are we likely to hear?
Yes, that's correct. And good evening to you and your viewers. Look, this issue is a bit of a slightly complex issue. Some years back, the Constitutional Court had to deal with the question of the role of a judge as the head of the Special Investigating Unit. And it formulated the position to be that work of that nature is not part of the central mission of the judiciary, and therefore offends on the separation of powers, because the judge will now be taking instructions from the presidency, because the SIU works on the basis of a proclamation by the president. So effectively, the president will instruct the judge what to do. Then, in this particular instance, the Public Protector challenged the rules with regard to the removal from office of Chapter 9 institutions. And the court found that in two respects, the rules were unconstitutional. One, because of the involvement of a judge, and secondly, because of the issue of legal representation, that they are entitled to have legal representation at the state expense.
Yeah.
So I suppose what is going to be an issue is whether the appointment of a judge in these proceedings offends the principle of the separation of powers. But we must bear in mind that this particular judge is a retired judge. It's not a judge in active service.
Advocate, were you proceeding?
Yes. But what the judge, the Western Cape High Court has said is that it is not against the appointment of judges to perform such duties, but they think in this particular instance it is not appropriate because, amongst others, this process emanates from the decisions of the court, the rebukes of the court against the Public Protector, but it also drags the judiciary into the political environment. Remember, the judiciary has been subjected to attacks.
Yeah.
Yes.
So whatever the outcome of this particular matter, though, that does not take away from the accountability matter, does it?
No, not at all. There's no issue about the fact that the Public Protector and all Chapter 9 institutions will have to be held accountable. I suppose what the Constitutional Court is going to focus on is the issue of what the role of a judge should be. And as I said, in this particular instance, the judge who's involved is not a judge in active service. He's a retired judge. And that may alter the position in terms of whether this judge... You remember now recently we had former Deputy Chief Justice Adv Modidima Mannya involved in an assessment of the local government election.
Correct.
We have had an active Deputy Chief Justice Zondo involved in a highly political charged case of the State Capture Commission. So it may as well be that the court may have to work out whether the central mission of the judiciary is compromised or not, whether, as opposed to whether there's a political environment or whether there might be a perception that the judiciary is involved in politics.
Advocate, on the basis of what you said, that in making reference to retired Justice Adv Modidima being involved in prior to the elections taking place, that decision there on whether elections would be free and fair, and also, given that you're saying this particular retired judge would be involved in this process, does it not work in the? It doesn't work in the favour of the Public Protector from where you're sitting?
Well, look, I don't think it matters. Let me put it this way.
Yeah.
If the Constitutional Court were to say, look, a judge should not be involved, it doesn't take away the fact that Parliament has taken a decision to hold her accountable and there is an impeachment process. It may just simply mean that the process of the investigation which led to the decision must start afresh without the involvement of a judge. So it doesn't change the facts. But where I have a concern is the fact that in all these instances, whether it's the process of Judge Museneke or Judge Zondo or the judge who was involved in this matter, they all make recommendations. So the bodies to which they make recommendations are not necessarily bound. The difference with the Special Investigating Unit matter is that it also involved taking decisions, not making recommendations. So I have a sense that it may be that the full bench may have erred in terms of how they interpreted this critical mission of the judiciary.
So if the Constitutional Court then rules that the involvement of this retired judge is not necessary, that would obviously mean that the entire panel itself would need to be reconstituted.
Exactly, because then the product of that panel would be an unlawful act, and you cannot rely on an unlawful act. So the panel will have to be reconstituted, and it will probably have to be a completely new panel. But the issue of the impeachment is a standing matter. I think there is a motion in Parliament. So the outcome of this case is not going to determine whether the impeachment will happen or will not happen. It will just delay and determine how it happens.
Some would accuse the public protector of delaying tactics in this particular instance. What do you think? Obviously, they would need to explore whatever legal means possible to them. Obviously, as you indicate, the process itself of, the fitness of the public protector, that issue still goes ahead. But what would then be the end game in this instance of challenging every single part of, I guess, the panel itself that has been constituted already?
Griselda, we are a constitutional democracy with a Bill of Rights. And we should not frown upon anybody who feels that they want to vindicate their rights. And I don't know why anybody would call a delaying tactic when somebody vindicates their rights. I mean, the public protector went to court. The court has found, and this is a full bench, this is 3 judges, found that certain aspects of the rules are unconstitutional. So she could have not been playing a delaying tactic. She asserted a right which was confirmed by the court and vindicated. The appeal was not by her to the Constitutional Court. It is by the acting speaker, the former acting speaker of Parliament. So it's not her who went to the Constitutional Court. It is Parliament which is challenging the Western Cape High Court judgment. So I cannot see why we should attribute any delaying tactics on her part.
Advocate Modidima Mannya, thank you very much indeed. Always appreciate your insights here on the program. Thanks indeed.